In this subunit, we're going to discuss how the consideration requirement impacts the modification of contracts. All right, let's set ourselves up for what we're going to discuss in this subunit. Remember, a promise is not legally binding unless the promisee gives up something of legal value in exchange for the promise. The promisee must suffer some sort of bargained for legal detriment. And that means she must promise to do something she had no legal obligation to do, or she must promise to refrain from doing something she had a legal right to do. But what if she already had a pre-existing legal duty? So what if she promises, but what she promises she already had a legal obligation to do? She had a pre-existing legal obligation to do it. Well, then there's no consideration, right? She suffered no legal detriment. Or what if she promises to refrain from doing something, but she already had a legal obligation. She already had a pre-existing legal duty to refrain from doing that. Well, then she suffered no legal detriment, and the promisor's promise is not supported by consideration. Well, how does this fit into the modification of contracts? Well, when parties enter into a contract, they then have pre-existing legal obligations, right? They have legal obligations based on their promises in the contract. If they now want to modify those obligations, they run into the problem that they are not suffering a legal detriment. We'll explain this in more detail in the following slides. All right, so what are we going to talk about in this subunit? Well, first, we're going to talk about why modifications of contracts can run afoul of the pre-existing legal duty rule. In other words, why modifications of contracts might not be supported by consideration. Then we'll talk about contract modifications that do not run afoul of the pre-existing legal duty rule. And then we'll talk about a special type of modification of contract, accord and satisfaction. Let's look at how the pre-existing legal duty affects the modification of contracts. So imagine we have a contract between house painter and homeowner. It's a bilateral contract. House painter promises to paint the house for $3,000 and promises to complete by October 20th. Homeowner promises to pay the $3,000. Clearly, this is a contract. We have mutual assent. We have reasonably certain terms, and each of the parties' promise is supported by consideration. Now, imagine halfway through the job, house painter, for whatever reason, says, I need $500 more. And homeowner agrees. Homeowner agrees to pay $500 more. Is homeowner's promise to pay $500 more legally binding? Well, let's go through our analysis. For homeowner's promise to be legally binding, the promisee, the house painter, must give something in exchange, must give something of legal value in exchange. What do we look for? We look for house painter's legal detriment. What legal detriment did house painter suffer in exchange for homeowner's promise? Nothing. Right now, you might say, well, house painter promised to paint the house, but house painter was already under a pre-existing legal duty to paint the house. The parties already had a contract where house painter promised to paint the house, and we said that that contract was legally enforceable. So, house painter was under a pre-existing legal duty to paint the house. So, when house painter promises to paint the house in exchange for homeowner's promise to pay $500 more, it was not a legal detriment. Therefore, homeowner's promise to pay the extra $500 is not legally binding. Let's talk about situations where the modification of a contract will not run afoul of the pre-existing legal duty. Our first one is the mutual modification situation. Here we have the same fact pattern. House painter promises to paint the house for $3,000, promises to complete by October 20th. In return, homeowner promises to pay $3,000. Halfway through the project, house painter asks for an extra $500. Homeowner agrees. Homeowner promises to pay the extra $500. Now, we said in this situation, homeowner's promise is not legally enforceable because it is not supported by consideration. House painter already had a pre-existing legal duty to paint the house and therefore suffered no legal detriment for this new promise to pay $500. But we can change the facts a little bit. Let's say that when we modify this contract so that homeowner agrees to pay an extra $500, house painter also promises to finish by October 19th, 1 day early. Now think about this. Was house painter legally obligated to finish the house by October 19th? No. So when house painter promised to finish the house by October 19th, it was under no pre-existing legal duty. Therefore, the house painter suffers a legal detriment and the homeowner's promise will be enforceable. The homeowner's promise to pay an extra $500. You might say, wait a minute, that looks like sham. Was it really bargained for? Was the homeowner really bargaining for the house painter to finish an extra day early? And the answer is, well, probably not. But courts are willing to look the other way in this situation. Courts are willing to turn a blind eye to sham consideration so that parties can modify their contracts. The courts recognize that, listen, this is something that parties need to do sometimes. Sometimes they need to modify their contracts, and they want to be legally bound by these modifications. So when they do their modification this way, with mutual modifications, even though one side seems to just give up sham consideration, courts are willing to turn a blind eye to it, and they're willing to say the modification of the contract is supported by consideration. All right, let's talk about the next situation where modification of the contract will not run afoul of the pre-existing legal duty rule. This situation involves the rescission of the original contract. So here's our fact pattern. I'm not going to repeat it. It's about the house painter and the homeowner. Homeowner promises to pay an extra $500. But this time what the parties do is that they rescind the original contract and then they enter into a new contract where the homeowner agrees to pay $3,500 and the house painter agrees to paint the house by October 20th, not a day early. Here it's just the same promise in the original contract. But because the original contract was rescinded by the parties, it no longer existed, and therefore neither of the parties had a pre-existing legal duty under the contract. So when they enter into the new contract where homeowner agrees to pay $3,500, $500 more than the original contract, and house painter promises to paint the house and finish by October 20th, the same promise under the original contract, house painter's promise this time is legal detriment. Why? Because house painter was no longer under a duty, a pre-existing legal duty to paint the house, because the original legal duty under the original contract had been rescinded. All right, we need to take a closer look at the rescission of the original contract. There's a very important consideration issue here that we need to understand. First, remember we said that the parties agreed to rescind the contract. You see that language, agree to? That means the agreement to rescind the contract, the rescission of a contract itself, is a contract. So in our fact pattern, we actually have three contracts. We have the original contract between the parties, we have a contract to rescind, and then we have the new modified contract between the parties. The new modified contract between the parties will only be supported by consideration, will only not run afoul of the pre-existing legal duty rule if we have the rescission of the original contract. And the rescission of the original contract is only valid if there's consideration for the rescission. Remember, rescission is a contract to rescind. So the contract to rescind looks like this. Even though sometimes parties don't actually write this, when they rescind a contract, they have made mutual implied promises. One, the homeowner, in our case, promises not to enforce her rights under the original contract. The house painter promises not to enforce her rights under the original contract. Those are the mutual promises of the parties in the rescission. Now, are these promises supported by consideration? Well, first, let's look at homeowner's promise. Is that supported by consideration? What did the house painter give in return? House painter promised in return not to enforce her promises. And you see how this works mutually. Here's the thing though. House painter, for example, will only suffer a legal detriment by promising not to enforce her rights under the contract if homeowner hadn't fully performed under the contract. So here's the idea. Let's say that homeowner had already fully performed under the contract when the parties rescinded the contract. Let's say homeowner had already paid homeowner had already paid house painter the full $3,000. Now, homeowner promises not to enforce her rights under the contract. Is her promise supported by consideration? Well, what did the house painter give up in return? Well, house painter says, I promise not to enforce my rights under the contract. But the house painter had no rights to enforce under the contract. House painter had already been fully paid by the homeowner because the homeowner had already fully performed. So sometimes you will see this in this modification fact pattern where the parties have a contract, they rescind the contract, and then they enter into a new contract. For the contract to rescind to be fully supported by consideration, both parties must have some remaining duties under the contract. All right, continuing on with modifications of contracts that will not run afoul of the pre-existing legal duty rule, let's look at a situation where the parties have a good faith dispute. So, same fact pattern, house painter promises to paint the house for $3,000, homeowner promises to pay $3,000. Let's say halfway through the job, once again, house painter asks for $500 more. But house painter now has a claim. House painter says to the homeowner, listen, you told me the house was this big and it's really much bigger, so I need $500. And homeowner says, no, I didn't. And house painter says, yes, you did. Now the parties have a good faith dispute. And I'm assuming that house painter is saying this and has a good faith dispute and is not just making this up. When parties settle a good faith dispute, there is always consideration. Effectively, what the parties are saying, listen, I promised to give up my claim, you promised to give up your claim, let's just settle this thing. And the settlement is the new contract. All right, let's talk about a special type of contract modification called accord and satisfaction. Let's look at a fact pattern. Let's look at the fact pattern between the house painter and the homeowner, and we'll change it a little bit to fit into the accord and satisfaction paradigm. All right, so house painter, once again, promises to paint the house for $3,000. Homeowner promises to pay $3,000. House painter this time finishes the job, and homeowner is unhappy with the work. Homeowner thinks house painter did a shoddy job, so homeowner thinks that she does not have to pay the full $3,000. Homeowner mails a check to house painter for less than $3,000. Homeowner mails a check to house painter for $2,500. On the back of the check, where house painter will sign the check, their homeowner has put some words, and the words are payment in full satisfaction of the debt. And then house painter cashes the check. This is the paradigm example of accord and satisfaction. This isn't the only fact pattern, but this is the one you will run into the most. Let's discuss it. All right, now, when we're talking about accord and satisfaction, we have to ask whether there was assent, and we have to ask whether there was consideration. First, let's talk about whether there was assent in our fact pattern in our fact pattern involving the homeowner and the house painter. All right, so effectively, by putting on the back of the check payment in full satisfaction, homeowner made an offer to house painter to settle the debt for $2,500. I owe you less than $3,000 because you did a shoddy job. I am offering this in full satisfaction. Do you accept? Was there acceptance by the house painter? Well, what did house painter do? House painter cashed the check. Is that acceptance of homeowner's offer to settle the debt for less than $3,000? Well, here, cashing the check is a bit ambiguous. Now, if we take the objective approach to contract formation, the objective approach to assent, we're asking, was homeowner reasonable in believing that house painter's act of cashing the check was acceptance of homeowner's offer to settle the debt for $2,500? Now, cashing the check alone is somewhat ambiguous. Here's why. If you owe me $3,000 and you send me a check for $2,500, right? I have a right to cash that check and seek an extra $500 for you. Just sending me a check for $2,500, that alone is not enough for you to understand that I'm accepting the check for $2,500 in full satisfaction of the debt. Right? So naturally, for you to believe that I am accepting less than what we agreed to as full satisfaction, I should be aware that we have some sort of dispute, that you are unsatisfied with my work, and in this case, that homeowner is unsatisfied with house painter's work. Does homeowner know? Has homeowner made house painter aware that homeowner is unhappy with house painter's work and homeowner feels she owes less, right? Now, the second part of this assent formula is that the house painter or the homeowner reasonably understands that the house painter is settling the dispute by cashing the check, right? Here, because homeowner put on the back of the check payment in full satisfaction, and if it was obvious to the house painter, then the homeowner is reasonable in believing that when house painter cashed the check, house painter was agreeing to accept less than the original contract amount of $3,000 in full satisfaction of the debt. So here in our fact pattern, what we're looking for in the accord and satisfaction situation is, was the party who accepted, right, was, in this case, the house painter aware there was a dispute, and was the house painter aware that the money was tendered in full satisfaction of the dispute? Only when we have both of those elements can we say that the homeowner was reasonable in believing that when house painter cashed the check, house painter was assenting to accept $2,500 as full satisfaction of the original $3,000 debt. All right, now continuing on with our analysis of accord and satisfaction. We just talked about assent. Now we have to talk about consideration. So we had a contract for $3,000. We had payment for $2,500, and let's assume that the house painter promised to accept $2,500 as full satisfaction of the debt. And we can rephrase this promise if we want to make it easier to understand. House painter promised not to seek the extra $500 or the remaining $500. Is house painter's promise not to seek enforcement of the remaining $500 debt enforceable? Well, that depends. Did homeowner suffer some sort of legal detriment, right? We run afoul of the pre-existing legal duty rule if homeowner does not suffer some sort of legal detriment. Now, remember when we talked about modification of contracts, we talked about good faith dispute. Here, the homeowner is unhappy with the work. The homeowner thought house painter did a shoddy job, and therefore homeowner believed that she did not owe the full $3,000. Therefore, there is a good faith dispute. When she settles that claim for $2,500, she is suffering a legal detriment. Therefore, house painter's promise not to seek the remaining $500 is legally binding. It is supported by consideration. The consideration is homeowner's legal detriment of settling the dispute. All right, continuing on with accord and satisfaction. Well, how is it different from modification of contracts? Up to now, it looks pretty similar to modification of contracts, right? You need assent and you need consideration. Well, it is slightly different. So first, let's look at the modification of a contract. So let's say we modify payment under a contract from $3,000 to $2,500. We have a modified contract. Now, if homeowner fails to pay the $2,500 under the new modified contract, house painter can only sue for that $2,500. We have a new contract. What's the promise by homeowner under the new contract? To pay $2,500. If homeowner breaches that promise, house painter can sue, but not for the original $3,000. House painter can only sue for the $2,500. Accord and satisfaction is different. So let's say we still modify the payment under the accord and satisfaction, $3,000 to $2,500. If in accord and satisfaction, homeowner eventually fails to pay, in the end fails to pay the $2,500, house painter can sue under the original contract. That is the difference between modification of contract and accord and satisfaction. Accord and satisfaction effectively is an offer for a unilateral contract. It's an offer for performance. So it is, in our case, it's an offer by house painter that says, if you pay me $2,500, I'll accept it as payment in full. And if you don't pay me the $2,500, I will sue for the original $3,000. That's how accord and satisfaction differs from the modification of a contract.